Despite its long standing as a center of international finance, Hong Kong legislation lags far behind that of the PRC in its approach to corporate rescue. In this Nova Courses course, we take a look at the features of insolvency and rescue provisions in each jurisdiction. As the full impact of the collapse of major financial conglomerates plays out in the global financial stage, which regime is better positioned to face challenges and seize opportunities? When the first rumblings of the U.S. credit crunch began nearly 2 years ago, few could have predicted the massive shockwave the events would have on the global economy. But with markets interconnected as never before, the breadth and depth of the crisis has become obvious on a worldwide scale. At this stage, no markets are entirely immune from the current financial volatility. But clearly, some are better positioned than others. And while financial institutions in Hong Kong and China appear to have relatively limited direct exposure to the investments that triggered the credit meltdown in the U.S., in both jurisdictions, legal advisors in the banking industry have scrambled. The existing Hong Kong statutory framework for distressed companies has been the subject of debate and criticism for decades, but competing interests have resulted in a largely stagnant body of law with respect to distressed companies. Even those amendments made in 1984 were disparagingly referred to as the Great Leap Forward to 1948, in that the Hong Kong body of legislation attempts to make headway towards a comprehensive regime in 2000 continued to provoke criticism, largely directed at matters involving secured creditors and the protection of employees. As a result, the city is left with an insolvency regime that neglects to address the needs of companies that still might be salvageable. The existing statutory framework is geared almost exclusively to the liquidation of insolvent companies, with no statutory means to provide for a measured, court-sponsored restructuring of distressed companies, notes David Mound, Managing Director, Alvarez Marcel. He continues, this has the possible consequence that distressed companies may end up being liquidated when perhaps there was a potential for a turnaround, given a period of breathing space under statutory protection from creditors. One of the strengths of American Chapter 11 procedures is that it allows for this super priority or so-called debtor-in-possession financing. Hong Kong offers no statutory protection for lenders in this situation. The alternative is to get all existing creditors to subordinate themselves to a new lender, which is normally impossible, Mound adds. A further reason why the current scheme of arrangement approach to restructuring in Hong Kong is not an effective corporate rescue tool is that the applications under Section 166, where a majority of the creditors must approve the arrangement, which is then further subject to court approval, do not trigger moratoriums on creditor actions. Dissenting creditors are not prevented from issuing proceedings against the company or presenting a winding-up position, making rescue unlikely. In the absence of super priority procedures, many companies have attempted to use provisional liquidation measures as de facto proxies for rescue procedures. While this approach has had success in limited application, more recently, the High Court appears to be stiffening its position with respect to using these appointments to affect the rescue. He refers to the Hong Kong Court of Appeal's recent decision in Re Legend International Resorts Limited, where the court rejected the role of provisional liquidators in restructuring or rescue proposals. In the Legend case, the petitioner based the application for the appointment of the provisional liquidators on the ground that he should have the power to explore a restructuring scheme for the company, since a viable rescue opportunity existed. The court rejected the argument entirely, pointing to Section 192 of the company's ordinance as the basis for the authority that provisional liquidators were to be appointed only where a winding-up order was made. In recent days, the Hong Kong government has jumped on the action plan bandwagon, joining other nations who have admitted the need to inject funds to underpin the banking system. It has announced its intention to quell public anger over the lack of regulation which allowed Lehman to sell billions in mini-bonds to the public at large, who argued that they were unaware of the risks involved in their investments and risked losing millions. Regulators in the city had been flooded with thousands of complaints before the government offer, which was. Meanwhile, as the Securities and Futures Commission begins its investigations into alleged mis-selling by banks, it is hoped that the government will not turn away from the larger lessons of Lehman as the inevitable filings for restructurings and insolvencies begin to unfold. The need to implement a solid approach to these matters in the future. After 12 years of drafting and deliberation, the PRC's new corporate rescue regime came into effect in August 2007. Billed as an effort to create a market-oriented bankruptcy regime, maximize space for corporate rescue, foster a better environment for insolvent companies to be reborn, and provide a more stable legal environment, the new legislation is a timely development for foreign investors in dealing with problematic investments. Before the bankruptcy law came into effect, the Chinese laws and regulations governing insolvency were fragmented and mainly addressed insolvency of state-owned enterprises. There was no legal framework for restructuring of distressed companies, and insolvencies were handled on a case-by-case basis, notes Felix Hess, associate at Salon's Shanghai office.